001732, Randall Eugene Schneider as the executor of the estate of Melba Rose Schneider, the deceased, versus Patricia Schneider and other occupants. On behalf of the estate of Melba Rose, Mr. Daves, you're doing a great job. You're on mute.
Okay, sorry.
I know, it's 2026. Happy New Year.
I'm here representing the estate today, the plaintiff.
The case involves Randall Eugene Schneider, acting as executor of his late mother Melba Rose Schneider's estate, against Patricia Schneider, who is living in the property. The court confirms both parties are present, with the estate represented by legal counsel. The case centers on possession of the property, which is part of the estate and needs to be managed according to probate law and the executor's duties.
All right, thank you for being here. We've not had anyone, let me just confirm, have we had anyone check in on behalf of the defendant, Patricia Schneider?
I am here.
Oh, good afternoon, Ms. Schneider. Fantastic. I hear you. Thank you for being here.
Okay.
Okay. All right, then. Mr. Daves, why don't you tell me why this case is sought?
Yes, Your Honor. It's a forcible detainer based on the fact that the estate needs to liquidate this property. Randall Schneider is the independent executor of the estate. The deceased estates consist mostly of real property, including the subject property here at 1702 Dwyer. The executor's sister, Patricia Schneider, is the defendant here. She's lived in this property for a number of years. There is no lease. There is no rent payment. And Mr. Schneider, as the executor, has asked repeatedly to see if she would move out and has given her a number of opportunities to do so. She's not taken advantage of that time to do it. One of the problems is that the estate has debts to pay. There's all sorts of, there's attorney's fees, executor fees, property taxes, valid expenses of the estate, all of which are going to need to be handled. And at the same time, there's issues with the property itself. It appears to be a hoarding situation. Folks come to the property to cut the grass and they're run off by the defendant.
The estate explains that the property must be sold to pay debts, including taxes, legal fees, and administrative costs. Patricia has been living there for years without a lease or rent payments. Despite being asked multiple times to leave, she has not vacated. The executor argues that this delay is preventing the estate from settling obligations and distributing assets to rightful heirs.
It's frankly a fire hazard with everything that's in there. They can't get insurance on the property, and none of the heirs can get anything from the estate until this is finalized. Mr. Schneider believes he has a fiduciary duty to the estate to liquidate these things. We have and have submitted to the court for consideration. There's a copy of the warranty deed showing that the decedent was the owner of the property at the time of her death. There's also a copy of the last will and testament. In that last will and testament, there's no specific bequests of individual properties to the defendant. Everything in the way of the property goes to the residue under the will. And under the will, the executor has the authority to liquidate properties, sell whatever he feels is in the best interest of the property, of the estate, I should say, and make distributions of money or in kind, whatever the case may be, to the heirs. And right now, he's not able to do that because of the circumstances and conditions surrounding that property. We've also submitted as a plaintiff's exhibit letters testamentary showing that Mr. Schneider has been appointed as the executor of the estate. And we also have a notice to vacate, which was dated November 12th of 2025, giving the defendant 5 days to leave. And it's not a CARES Act property. It was sent certified mail and regular mail. So that's essentially our position, Your Honor. When we look at the Texas State Property Code, 101.003 says that on the issuance of the letters testamentary, the executor has the right to possess the estate. And then under subsequent parts of that estate code, the decedent's estate vests, but that's subject Two, debts being paid, and that's where we are now. We need to pay the debts and can't do that right now with the situation that we're dealing with.
All right.
When will I be allowed to respond to any of that?
Actually, Ms. Schneider, now is exactly the right time for that.
Okay. I have never run anybody off of the property that wanted to cut the lawn. That's number one that I heard that was wrong. I've never interacted with anybody that's come up to want to cut the lawn. So I don't know where that came from. I have chronic illness that I've dealt with over years, and I have been trying to move. Initially, I was supposed to get everything out of my mother's house and move it here, which I was trying to do.
The plaintiff also raises concerns about the property's condition, describing it as a hoarding situation and a possible fire hazard. They claim workers have been turned away and insurance cannot be obtained. These issues further complicate the estate's ability to sell the home and resolve financial matters, increasing urgency for regaining possession of property.
For several months. And then it was decided that I could not afford to stay here, so I had to reverse everything that I had already moved and go back the other way. I have a lot of bad health days, and on good days, I tried to contact lawyers. I tried to find help to help me move. Everything costs money on my end. No one else in the family has to pay movers to get their inheritance. I'm trying the best that I can, and I have been trying. I was finally able to get through to TRLA today and do not qualify. So that will be another phone call day that I'll have to spend to try and find some representation. I need someone that will advocate for me. My health is not good. My mother knew that, and she let me live here to be close to them initially because they lived down the street, and I was here to help them for several years until they moved back out to their usual residence, where I continued to help her until she went into assisted living. I am trying to get out of here, but I have no help, and I have to introduce myself to strangers and let them into my life, and I don't know that they're not going to hurt me, especially when I'm down. And there are days that I can't function at all. But I've dealt with this illness for years, and I get back up on my feet. And people think that nothing's wrong with her. She's here, but they don't see me when I'm not well. And I don't know how I can convince people. I guess. I am trying, and that's...
Ms. Schneider, I appreciate all of that, and it definitely sounds like you're trying. What I've heard, though, is essentially an acknowledgement that what Mr. Daves told me is correct. So the property was owned by your mom. She's passed away. It's now in a probate status?
Yes, Your Honor.
Right.
Okay, and you received the notice from Mr. Daves indicating to you in November that they wished for you to move out so they could sell the property?
I didn't receive anything until I received the court papers in December.
Right. They did provide me, I'm going to share the notice to vacate because they provided me with all the tracking information as well. But they did provide a copy of the notice to vacate from the Daves firm in November, providing you with 5 days notice. And then here is the
Patricia denies interfering with workers and explains her situation. She suffers from chronic illness, has limited finances, and struggles to manage moving alone. She says she's been trying to relocate, but lacks support and resources. She also mentions difficulty finding legal assistance and emphasizes that her health condition makes daily functioning and decision-making very challenging.
I think that was included in the packet.
I'm sorry, ma'am?
That was included in the packet. but I had not received anything before the December date.
All right. Ms. Schneider, Mr. Daves, thank you for the information. I do hear a case for what would be, Ms. Schneider, I would agree with the assertion based on what I heard that you've been living there for a period of time. Rent was not a requirement for that. That makes you what's called a tenant at will. And then once you receive notice from the executor that they needed you to move so they could sell the property and you have not moved out, you become what's called a holdover. And so either of those things get the plaintiff where they want to be at. What I have to do, though, is in addition to awarding possession and cost of court, I have to come up with some type of an appeal bond amount. And since there's no rent here, I'm going to be taking a bit of information. Mr. Daves, do you have any sense of what market value for rent would be, or the size of the home, kind of the mortgage on it, or what might have been?
Right. There's no mortgage on the house, and it's in pretty bad shape right now. It's, again, a hoarder situation from everything we can tell. I don't know what sort of market value it have in its present condition. That's part of the problem we're running into now, and trying to sell it. We can't. But if I had to guess, I would say,
well, the property taxes are $19,000 a year on it. So.
Listen, we're in Travis County. We've our tax bills. But let me ask you this: give me the
Well,
step
no, but that gives
It's
you
a single-family home.
indication what it's worth. I mean,
but anyway, sorry, Your Honor, what's that?
Is it a single-family home?
yes. It
Okay. What's the square footage?
Two bedroom.
is. 1,100 maybe.
Ms. Schneider,
1,100
that
square
sound about
feet.
right? 1,100 square feet?
Yes, ma'am.
I was asking the defendant. Ms. Schneider, since you were there, that sound about right?
I have no idea of square footage. I would go by whatever Zillow says, you know.
All right, well, I'll just say that a two-bedroom and 1,100 square feet matches up with what I typically hear and see. So that all seems reasonable to me. All right.
Yeah.
How about, is there more than one bathroom?
No, there's just
One
one
bathroom.
There's two bed, one bath.
This is located in
Right.
Zilker Park,
It's in the
correct?
Zilker area over there off of Kenny Avenue and Barton.
Oh, goodness. So you got a little bitty house with a gigantic tax bill.
Exactly.
Right.
I know, I block walked in Zilker Heights. They're beautiful, but wow. Okay.
Yeah.
All right. Given what I hear then, for the type of the property, the location, the fact that rent had not been due here yet, we still need to secure the property for parties. I think it'd be reasonable to put down $2,500. For that type of property with going market rate, that seems reasonable for both parties. So we'll send that to each
For
of you.
what?
So Ms. Schneider, what that means is that if you wish to appeal, you have at least 5 days to appeal. In the 5 days, if you wanted to appeal, the appeal bond is $2,500. If you wanted to appeal, but you don't think you can afford it, you may qualify for what's known as the affidavit of inability. I don't know, and I can't tell you whether you will or not. I don't know your financial situation. But that's what the appeal bond does. Okay, if you wanted to appeal and you can't afford the appeal bond, well, then it comes to the end here. But you have at least 5 days to take it to get information and to look into that, and we will send both you and plaintiff's counsel a copy of the order along with information related to appeal. Okay. Can I answer any questions first, Ms. Schneider? Can I answer any questions before we excuse you from court today?
So I'm not sure I understand. I have 5 days to appeal.
Correct. And if you don't appeal on day 6,
How do I do that?
we are going to email you and physically mail you paperwork with detailed instructions if you wish to appeal, where to do it, where to go, and how to do it.
And I have to pay?
The
do
bond
it?
is, that's correct. There's a $2,500 appeal bond. You may qualify to appeal without filing the money. We'll send you the information, and again, it's not up to the judge. You fill out a form, and if you qualify, you qualify. If you don't, you don't. Ms. Schneider, if
Okay.
you take no action, the soonest the landlord, or in this situation, the executor, Mr. Dave's client, could receive, the soonest they can get a writ of possession is on day 6. And you have at least 5 more days before any legal action is taken, or any additional legal action is taken.
Okay.
All right. Mr. Daves, any questions?
And what would be the additional legal action
It's if either one of you appealed.
if either one of us appeals?
Correct. But if neither of you do
Okay.
anything, the judgment is final, and then beginning on day 6, the landlord has up to day 60 to seek a writ of possession, and if you haven't loathed, they would remove you and your items.
They have until day 60 to seek a writ of possession.
Correct. They can do it as soon as day 6, but they can wait
Okay.
up to 60 days.
Okay.
All right. Thank you both for coming then.
Thank
Good
you,
luck to
yeah.
both parties. We will send you all your information. And with that, all parties are excused.
The judge acknowledges her hardship, but explains the legal position. Since there was no lease, Patricia is considered a tenant at will. After receiving notice to vacate, she became a holdover tenant. Based on probate law and the executor's authority, the court determines that the estate has the legal right to reclaim possession of the property.